Welcome to Halal Money Matters, sponsored by Saturna. I'm Monem Salam. And today's episode, we're really going to be digging a little deeper into estate planning. You know, in Malaysia particularly, it has a dual estate planning system, or you can call it a dual legal system. So one on the Sharia side and one on the conventional side. And how do you navigate through the landscape? When do you choose one over the other? And how do you leave money behind to your children and for other causes according to Islamic principles and still do it in a tax-efficient way? So today we have a very special guest, Ariffin Bin Sabirin, who's with wasiyashop.com. He has a tremendous amount of experience in this area of estate planning. He's given lectures all across the world, specifically on what Muslims should be doing when it comes to leaving their inheritance. I'm really excited to have him on, so let's get started. So Brother Ariffin, thank you very much for joining us today.
Welcome, brother.
I'm really excited about this topic because, this is, I think, a topic where the world over, it's a very, very difficult subject to talk about, right? I think the thing that people least like to do is to talk about death. And what they really, even more than that, is actually talk about their own death and what's going to happen after that.
I've been in the industry for 29 years. Brother Monem. And in Malaysia, I just want to share Malaysian experience. In Malaysia, when I first started in the industry in 1998, there were virtually no discussion at all about tariqah or about estate planning. You know, everybody would just keep quiet about it. They think that this is going to be a natural flow whereby after your demise, your estate is going to be distributed accordingly. There is no problem on it, you know. So it's like a taboo subject. It's like a taboo subject, and rightfully said, nobody wants to discuss about what will happen to our estate after our demise because the death itself is a big taboo to us.
Well, that's interesting that you mentioned that because, you know, in America, obviously there's no Sharia governance laws in America. And so we encourage Muslims to be able to have their estate planning done and those type of things. But one of the things that we tell them is, hey, you know, it was easy to do it back in your home country because there was established Sharia laws that would allow you to do the distribution of assets or the wasiya after you died. Are you saying that that's not necessarily the case?
No, not necessarily, because personally, I've been invited to give talks to a lot of countries, Middle Eastern countries, some Europe countries, UK, Turkey. You know, I found that if I talk about estate planning, it has to be local in context. If you are Qataris, you need to look at the Qataris legal framework. But of course, you would have assets located all over the world because now we are a global community. So if you talk about asset in other countries, you need to look at that particular country's legal framework. So the more assets you have scattered all over the world, the more complicated and comprehensive your estate planning should be. So it's not like, you know, I understand your approach. There is this, even in Malaysia, you can do up inheritance planning instruments in Malaysia, and it is actually applicable for assets outside of Malaysia, but the legal processes would be long and it will be quite tedious.
Yeah. So if I'm young and I have little assets or maybe no assets because I'm just getting started and I happen to pass away, you know, what do I have to have an estate plan, or will the courts or the Sharia courts solve everything for me because I'm a Muslim?
Yeah, that's one of the most common questions I've met in my years of experience in this industry, because people will say that I do not have that many assets. I only have a car, I only have a bank account. So should I do my estate planning or not? In Malaysian system, as long as you have an asset, even you only have just one bank accounts. That bank accounts, in order after your passing, in order for that bank accounts to be liquidated and transmitted to your rightful beneficiaries, you still need to go through the legal processes. Okay, so in Malaysia is broken up. If you're taking because we have a dualism system, we have civil and we have Sharia law. The Sharia court who administer the Sharia law will principally look into who gets what, who are actually your beneficiary and what are their portions. The civil law or the civil court will actually administer the estate process. So this both system actually run concurrent in the system of inheritance in Malaysia. So even if you just have one bank account, you need to go through the legal processes.
Yeah.
Yeah. So do I need to do my inheritance instrument, do up my inheritance planning or not? Depending on your wishes. If you are looking at all your estate to be distributed according to the Faraid law, so you need not to do any planning at all. Okay? Because that will be your one bank account will be distributed to your Faraid beneficiaries. But if you even though you only have one bank account, but you already have a spouse, you have a kid, and normally youngsters when they just starting their family, they would have a spouse, they would have small kids, So you want to ensure that your spouse and your small kids is being protected. You can actually do up your inheritance instrument.
Okay. So, and in this particular case, also, let's take an example of, so young family, young kids, right? And the husband passes away, or both, unfortunately, end up passing away. Is there a system in place already for what happens to the children, or is that something that needs to be thought out in advance in an estate plan?
Yeah, Malaysia is unique because we have 14 different states. And in the constitution of Malaysia, these 14 states have jurisdiction over religious matters. So who gets what? The beneficiaries, according to the Sharia principles, falls back to these 14 states. So each states would have a different Sharia framework, but nevertheless, they are quite similar. There is a system in place in the Sharia law whereby if the husband and the wife pass away simultaneously, what happened to the underage children? Who will actually take care of the underage children? The system in Malaysia has stipulated that as far as the custodian of the asset is concerned, there is a specific law determining who will become the custodian of the estate for the underage, and there is also custodian of the children itself. So there is two different angles: custodian of estate, custodians of the children. So the law in Malaysia, all in the 14 states law, they have actually stipulated that. So
is it where I'm
worries.
living, or is it where I was born?
Where you are living, your domicility.
Okay. And then also
so
it gets more complicated, right? 'Cause I was born in, let's say, in Perak. I live in Kuala Lumpur, but I work in Selangor, or something like that. So and those becomes a little bit more complicated too. So yeah. Which makes it more of an idea of why you should have something written down.
In some of the countries, Brother Monem, which I travel, they only have one centralized legal system. So it's very easy. But in Malaysia, we have 14 different states. So that's what we have been doing over the last 21 years of our establishment, going up and down to the 14 Sharia courts, and meeting 14 different head judges, which have their own perception.
That's true. And just so we can clear this up initially also, is there a difference between like a Malaysian Muslim and a Malaysian non-Muslim when it comes to the estate planning?
Yeah, for Malaysian Muslim, it's stipulated in the constitution that the law binding the Malaysian Muslim as far as inheritance is concerned is a state law. For the non-Muslim, the law that binding the estate situation for non-Muslim is the federal law. So for non-Muslim, they can use will because will is enforceable. They can bequeath their estate to anybody. It's enforceable on whatever formula. They can also use trust, which is quite a common instrument for the non-Muslim. For the Muslim, we can use will, but will or wasiyah in what is called in Sharia, wasiyah is only applicable if you want to bequeath a maximum of 1/3 of your estate to non-beneficiaries for the purpose of charity. Non-beneficiaries is charity organizations, your adopted children, these are non-beneficiaries. But if you use a will to bequeath your estate to beneficiaries, parties who are actually receiving your estate based on the faraid portion, that will depends on the beneficiaries themselves after your demise, whether they are agreeable to not.
Okay, kind of back to basics. So the Quran stipulates, right, exactly how the distribution of assets should be. Out of
Right.
that, that's where in the ayahs in the Quran, when the wife gets 1/8, and if you have children
Yeah.
but no daughter,
Yeah.
that type of thing. Okay, then you have 1/3 of all of your assets, right?
Yep.
Because at any point it basically says 1/3 of your assets you can give to anybody that you want, who is
Mm-hmm.
not a direct beneficiary. So it can't, 1/3
Correct.
cannot go to that wife or the children, those type of things. But you can actually, and also the other stipulation is that first out of all of this, your debts have to be paid off.
Correct. Correct.
Okay.
So chronologically, what practice in Malaysia is that when you pass away, all your asset is considered as your estate. So you need to first deduct your debts, whatever liabilities on your estate. You need to deduct that first, and then you have the balance of the estate after deducting your debts. That balance, actually, you need to deduct wasiah, 1/3 wasiah, if there is any, because it's just a sunat muakkad, it's not something compulsory for you to do it. So if there is wasiah 1/3 which you bequeath to non-beneficiary, so you need to deduct that first, then only you get the net balance, and that net balance is the one that we distribute to all the beneficiaries according to their faraid portions, or they can also compromise on the formula.
Yeah. And the debts you're talking about would be like a car loan. It would be like a house
Yes,
loan.
house loan, correct. Correct. It must be paid off first, and including your nazar. If you have nazar during your lifetime and it's known by your family, you have nazar.
Sorry, what's nazar again? Explain.
Nazar wishes that you want to do something during your lifetime, which is your promise with God. If I get promotion, I would sadaqah 10,000 ringgit
Okay.
of my money. So that is nazar. So you need to deduct that all obligation first.
Okay. So then we have the faraid that's already taken care of, right? We have the debts
Okay.
that'll be settled first. Then we have the
Right.
the wasiya. So the technical part of that's estate planning really comes in planning the actual wasiya part of it, which is the 1/3, right?
Right.
Are there any generally are there any estate taxes that you have to pay on when a person dies in Malaysia?
No, not in Malaysia.
Okay.
There was an estate taxes, but it was abolished in 1988.
Oh.
So there's no estate taxes here.
Okay. Okay. So we don't have to worry about taxes. So let's supposing you have now the 1/3 left over. So what are some key components of that 1/3? What am I allowed to do with it? Not allowed to do with it from a Malaysian concept?
Okay, probably I should explain also about the inheritance instrument, particularly hibah.
Sure.
Because there's always this confusion between hibah and wasiyah. What is hibah? What is wasiyah? Wasiyah is strictly for charity purpose. 1/3 bequeathed to non-beneficiaries. Hibah is more flexible in terms of distribution your asset. Okay? So the difference between hibah and wasiyah is that hibah is enforceable during your lifetime. Wasiyah is enforceable after your demise. Hibah is applicable for your asset during your lifetime. Wasiyah is applicable for your estate after your demise. So there's a clear distinction between wasiyah and hibah there. And I think in Malaysia, hibah is a widely used instrument. We pioneered hibah instruments in 2004 and start introducing hibah as one of Islamic wealth planning instrument. And it has been widely accepted. In 2013 in Malaysia, the Islamic Financial Services Act 2013 was enacted, and one of the schedule in that law talks about hibah of takaful. Takaful benefits. So since then, I see since 2013, the usage of hibah and also the demand of hibah has increased significantly.
So just to clarify, hibah in Arabic means gift, and
Gift,
also
correct.
same in Bahasa Melayu, it means gift as well, right?
Correct.
And so what you're basically doing is you're saying during my lifetime, I will give a hiba to a
Right.
particular person, right?
Right.
That becomes much more constrained after I
Mhm.
die, right?
Mm.
Because that then becomes wasiya. It cannot be a
Right.
gift anymore, correct?
True. Why the public in Malaysia, the community in Malaysia, give a good response to hibah is because they see the flexibility of hibah. Because you can give hibah to anyone. Wasiah is only constrained to non-beneficiaries. If you give wasiyah to your wife, for instance, your wife is already beneficiaries under the Faraid law. So whether your wife will receive that wasiyah or not, it depends on the other Faraid beneficiaries. If they are agreeable to it, it's okay. But if they're not agreeable to it, then the bequest is null and void. On the other hand, Shiba, you can give to anybody you want. And it is very interesting to note that we have successfully execute hibah from a Muslim to a non-Muslim. So it's not just you can only give it to Muslim. You can also give it to a non-Muslim because the principle is that hibah is a gift.
No.
So you can give your asset to whomever that you want, be it beneficiaries, non-beneficiaries, or be it a non-Muslim, or be it an organization. This hibah for non-Muslim, we have successfully executed it in Sabah, one of the state of Malaysia, because in Sabah it's very normal for the parents to be Christian, but the children to be Muslim, and they're living in the same house.
Sure.
It's very normal. It's very cordial and harmony there. So that we have done in Sabah. We have also have services. We team up with Wakaf An-Nur in Johor, whereby the donor can actually hibah their asset for wakaf purposes in Johor. So hibah is very flexible because you can actually fine tune it, tailor-made it according to local context. That what we have done so far. And as pioneer of hibah in Malaysia, we've seen tremendous significance shift in terms of awareness and also in terms of response from the public.
So if I want to give a hiba to my wife, right? Do I have to give, like, supposing I have an investment account, and that
Right.
investment account I want to give to my wife or my daughter or whatever,
Okay.
right?
Okay.
Do I literally have to change the name of the account or transfer the assets, or can I say, well, I'm giving this gift, but only after I die?
Okay. The principle of hibah, I encountered, brother, a lot of these questions. Does hibah means the outright transfer of ownership of the assets, be it properties, be it investment account? The research that we have made, we are a research based company. We give grants, a lot of grants to universities to research on products that we want to develop. Only after we got the research finding is fine-tuned according to the Malaysian law, then only we launch it as a product. So the research findings that we got over the last 20 years, this last 20 years of operation, it shows that hibah need not necessarily means you must outright transfer the ownership of the asset to the donee. Because as far as Sharia principle is concerned and the Sharia law application in Malaysia is concerned, a hibah is valid when the pillars and also the condition has been perfectly executed during your lifetime. So what are the pillars? The pillars are the assets. The asset must be yours, legally yours. Donor, there must be a donor, donee, and there must be an ijab and qabul. Okay, so once all of this has been perfected, the pillars has been met. But of course, in Malaysia, because majority we use Shafi'i opinion, in the Shafi'i opinion is that in order for the hibah to be enforceable, not only the pillars must be executed, there must be a condition met, and the condition is called al-qab. Al-qab means tasarruf or possession of the assets. The title is still under your name. You have hibah to your children. Myself, for instance, I have 3 daughters. My Faraid beneficiaries are my wife, my 3 daughters, my mother. My mother is still around. My father has passed away a long time ago. I have 4 younger brothers. So the 4 younger brothers is also my Faraid beneficiaries. I bought a few houses and I bought these houses for my 3 daughters. So what I have done is I have perfected the pillars and also the condition of hibah, and it's all documented properly to my three daughters. So if all these assets, all my assets worth, for instance, 10 million, and these three houses worth 1 million each,
Right.
since that I have perfectly executed all the pillars and also the condition, so these three houses or these 3 million worth of asset is not considered my estate anymore because I have hibah it to my three children. The title is still under my name.
Okay.
So in Malaysian court, there are written judgment by Malaysian Sharia court stating that transfer of ownership is not considered as qabat. Is a part of qabat, but it's not considered as the only qabat. For the Sharia Court of Malaysia, and there are some written judgment on it, stating that transfer of ownership is only administrative matters.
Okay.
So the Sharia matters is that when you execute your hibah, the four pillars and the one condition, the qabat condition, must be met.
Okay.
Then it's considered done.
Alhamdulillah, that's a really good way to do it. And then also, I've heard in some places also, and wanted to ask you about it from a Malaysian context as well, is that you can basically write almost like a debt instrument, right? Like I owe my wife this much from her lifetime for helping me take care of my kids, and she was the home, I was working, that type of thing. Is that also enforceable within Malaysia as well?
Correct. In Malaysia, we have these matrimonial property concepts. When I travel to Middle Eastern countries, they don't have that concept because in Malaysia, it's codified from our custom, our long served custom.
Yeah.
So if I borrow money from my wife for whatever purpose, 100,000 ringgit, for instance, I can write an IOU notes. She sign it, I sign it. We go to the notary, and the notary endorsed it. This 100,000 IOU notes from a husband to the wife can be deducted in the estate chronology, which I explained earlier on, can be deducted as one of the debts, because when you owe money from your wife, that is a debt.
Yes.
But when your wife asks money from you and you give, that is nafkah. So there's two different concepts. Some people, sometimes people get confused. I owe her money, but she also owe me. No, for husband, when they give money to the wife, that is a nafkah. Okay. Again, so that can also be deducted according to Malaysian law. In some of the middle countries, that was not accepted. Middle Eastern countries, that was not accepted.
So now we talked a little bit about the gifts, the hibah, the gifting part. We talked a little bit about how also being able to pass money to your heirs in regards to a loan or some kind of a debt instrument. Now let's get into the estate planning part, right? And what are some best practices that you've seen, not from a perspective of maybe even not only from giving it to your beneficiaries, but more importantly, which is something that I really stress upon, is how do you enforce sadaqah jariyah, after you've passed away? Sadaqah jariyah meaning ongoing charity, right? To being able to help people out after you've passed away, because that's one of the things that you'll have to continue to get deeds from those things. So if 1/3 is what I'll have to do, then make that 1/3 the biggest amount possible. So what are some tools I can use?
My company is a tailor-made boutique Islamic inheritance company. So what we do is that we do a lot of research, and we found that a lot of millionaires, high net worth customers, they are actually philanthropists. Even during their lifetime now, they're contributing to mosques, they're contributing to charity organization, and they would want their children to continue the habits. The sadaqah jariyah habit. So one instrument they can do is they can do trust instrument, and we have a trust instrument. We call it Naufal, whereby they can actually place the fund or allocate the fund to this trust instrument for the purpose of charity. So assuming they have been paying sadaqah to their mosque 10,000 ringgit a month for electricity bills and everything. So upon their demise, the trust instrument which they have actually set up can be used to continue with the sadaqah jariyah, the 10,000 ringgit a month. Okay, so that is one instrument they can use. They can also, of course, use wasiyah, the wanted wasiyah, and they can also use hibah. I'm glad to explain the hibah lil wakaf instrument that we developed with Wakaf An-Nur in Johor, whereby these people actually hibah their properties to Wakaf An-Nur. The difference between the Wakaf SOP and also the Hibah SOP is that for Wakaf SOP, you need to execute the transfer of ownership now, because that is according to the Wakaf law of all the 14 states. So you need to outright transfer your properties to the religious council of each of the state. But for Hibah, you can actually still enjoy living and getting benefits from the property itself. If it generates rental income, you can enjoy the rental income, of course, with the agreement, consent of Majlis Agama Islam or the religious council. But there's a flexibility on it. So for Muslim, Sadaqah Jariyah you can achieve in Malaysia from trust, charity trust, from wasiyah, wanted, and also from hibah lil wakaf, which we developed with Wakaf An-Nur.
That's really good. And then also, so let's suppose we're now talking about the trust aspect of it. So after you pass away, money from the 1/3 goes into the trust. The trust can get invested, and then the returns on the investment can be used for the sadaqah jariyah, right?
Yeah, if it is instructed by the settlor, is it instructed by the person who created the trust that this investment, this trust fund should be invested here, managed by these fund managers. If it is instructed by them, we can do that.
Okay. And that's a fairly straightforward process, I'm assuming.
Yeah, correct.
To be able to do that. Okay, great. Talk to me a little bit about some of the roadblocks. What are some challenges that I might face? I know one of them is there's a difference between calling something a waqf and calling something a trust.
Wakaf is jurisdiction of the 14 states. So all these 14 states would have a different interpretation on how to execute a wakaf. So that is a challenge. And the challenge with the state is because the properties, the assets that has been wakaf, except for cash wakaf, which is quite different. But property wakaf, I think the challenge for the religious council of the 14 states is to convince the community that if they wakaf their properties to the religious council would actually manage the wakaf properties efficiently. Because although wakaf is under jurisdiction of the state, but realistically the state is not equipped enough, be it in terms of capital, be it in terms of knowledge, be it in terms of human resource, to exploit the wakaf property to the maximum. So the issue of trust among the community is still relatively high. They know the concept of wakaf. They want it to be a perpetuity deeds for them after their demise, but they are not confident enough that whatever properties that they wakaf to the religious council will be effectively and efficiently managed.
Yes.
So they opt, because from wakaf they opt for other instruments, and the other instrument is trust, because for trust they can actually instruct. My company was Yashok Berhad, is a registered trust company in Malaysia, so they can actually entrust us with the properties to manage the properties, collect rental, maintenance of the properties and all, of course we're going to be charging all our service charges, but the proceeds of the rental, they can instruct us in the trust deed to be channel for the charity purpose. And that is where I explained earlier on, we have this trust concept we call Naufal, whereby the client can actually entrust their asset, their properties to us, and we will manage it on their behalf, because that is the local standard or the power of a trust company enacted for us.
So you're a trust company that can do it. Can you make the trustee one of your family members?
In 2017, we launched a product called Mutahabah. Mutahabah means mutual love. That's what it means. So it is actually a family trust whereby Wasiat Shah Berhad, we become the owner, quote unquote, the trustee of the asset. But how to manage the asset, where to distribute, how much, we would encourage the family members, the children, the grandchildren to be involved as committee of the trust. So the committee of the trust operates within the framework of the trust, which has been set up by the settlor, by their father. Their father has set up, okay, every month I want this money from the trust fund to be channeled to the amount of 100,000 for charity purpose. And we advise the father so that the children can be pulled in as the committee of the trust, so that they will work together and they will decide, okay, this 100,000 is structured by our father, which charity that we want to give, what type of charity activities that we want to do. So this cultivate the spirit of sadaqah jariyah
Yes.
to the next generation.
Very
We
true.
always encourage that, madam.
Very true. So even in this particular example, there's still you as a trustee that's involved. You're just getting the kids involved. Is there a form of trust where there's no corporate trustee? There's only the family member who's doing everything. They're doing the investment. They're doing the distribution. They're doing everything.
Yes, there are actually wishes of some of our clients where they want only their family members to fully operate the trust, which is okay with us. We have done that before, but there are risks. What are the risks? The risk, there could be manipulation, because the family members could coalesce together and then decide that, okay, let's not do this anymore. Our father has passed away. He doesn't know what we're doing now. We can just liquidate, sell off, and take our proceeds. So with Wasiat Shah Berhad as a trustee for the asset, even though liquidation can also be done, but it must be done under certain stipulations. So it is better to have a trustee as an oversight body to ensure that the wishes of the settlor is being carried out, rather than giving everything for the beneficiaries to manage. But if our client wants it that way, they want the beneficiaries to involve because they don't want to pay service charge or whatever to Wasiat Shah Berhad, it's okay with us. It's also doable.
Okay. All right. What are some common mistakes that you found people make or Malaysians make when they're planning their estates in Malaysia?
I think the most common mistake is the ideal perception. The ideal perception is that I don't have to do anything. My children's are okay. I have raised them well, with all the religious teachings and all. I've raised them very well. Their relationship is very cordial. So I don't think I should waste money on doing up my inheritance instrument, because everything's gonna go smooth. And from my 29 years of experience in this field, brother, that is not always true. Because once the parents pass away, because you must remember, I have 3 daughters. I have 3 daughters. I know how I raise my daughters, but I do not know where my son-in-law comes from. I do not know their background. I do not know their attitude. So there is always this uncontrollable external factors that will actually influence the relationship of the beneficiaries after our demise as parents. So that would open up the floodgate, because we have seen that cases before. The brothers, the siblings are very good, harmonious relationship, but after the parent passed away, because of estates, and these estates are quite valuable estates, they fight tooth and nail for it.
Yes.
So the family institution crumble after the parents pass away. So the most common mistake is for parents like us, we have children. The most common mistake is that we have this ideal perception, inshallah everything gonna go okay, everything gonna go smoothly because our children's are good, our children's relationships are good. That is the most common mistakes.
I appreciate that. That's a very, very good point. When is the right time, if any, to be able to start the process of estate planning? And then the second part of that is, how often should it be revisited?
Yeah. Okay, number one, when is the right time? When you're still alive. When you're still breathing. There's no I think there's no instances because I've met questions like, I only have one house, one car, just one bank account. So I think I accumulate my wealth first, and after I'm quite stable, I have I have sizable asset. Then only I want to go to planning. But sometimes our planning and God planning is different. So the right time is when you're still breathing,
Yes.
when you're still alive. And I've been talking about hibah in our session, and how the second question, how often you should revisit. Hibah, like I mentioned, is flexible. If you give to your children, you can revoke it ex parte, one-sided party, anytime you wish. So hibah is very flexible. That's why hibah in Malaysia is getting a very huge response. I hibah all these houses to my three daughters. Touch wood, but if anything happen, I might change my mind. I do not want to give my eldest daughter for whatever reason. So I want to give to my two daughters. I can actually revoke the hibah and I can give it to my two daughters. So how often? There's no specific time frame, but we have about 100,000 customer that doing hibah with us. It is normal for the customer to come back to us every 3 to 5 years when their portfolio changes, because sometimes they hibah this asset and then they acquire new assets. Sometimes the existing asset they have sell off. They have sell off, they get cash and they want to do something with the cash. So because their portfolio changes from time to time, the situation changes from time to time, we see our 100,000 over customers coming back to us within a time frame within 3 to 5 years.
Yeah, and also I think another good rule of thumb is many major life changes, right? You have a new child, one of your relatives dies, you get divorced. That's the biggest part of it. If you named your wife as a hibah, and then now she's your ex-wife, if you don't change anything, your ex-wife is going to get a really nice hibah.
I just want to put a note there. When you hibah to your wife, it's not revocable unless you give consent to it. Okay,
I see.
Hibah is revocable only hibah from usul to furuk, parents to children, grandparents to grandchildren, usul to furuk. That one you can revoke it anytime, ex parte. But if you hibah to your wife, you want to revoke it, you need to get her consent, and that would be problematic if you're already divorced, because we have seen cases like that. Is it the wife, the ex-wife, go and caveat the properties in the land office. So obviously the ex-husband came back to us, said, I want to revoke this hibah. The only allowed principle under the Sharia is that since that this is your wife, you need to go back and get her consent, which obviously he will never get.
Of course. That's right. Alhamdulillah. And then one last question that I have for you. It's a little bit off the topic, but I'm sure you'll be able to answer it. When I lived in KL for Kuala Lumpur for quite a few years, and you would see in downtown, like KLCC area or those things, you would see building, and then an empty land. And that empty land is now a parking lot. And you're building, empty land. And one time I was just talking to one of my friends, Malay friends, and he said, all these empty lands with parking lots, these are all lands that are in dispute after somebody passed away. Right? True. And so just your comments on how does that happen? Like how does, and some of those have been there for like years upon years, decades or sometimes that long. So how does that happen? Or what did they do wrong? And what can we learn from that?
Yeah, that's why we keep educating the Muslim. Upon demise, execute the inheritance, the estate process as soon as possible, because you do not want the existing beneficiaries to pass away while waiting for the estate process to be settled. Because when they pass away, their beneficiaries will come into the picture, successing their father or their mother's portion. That's why in Kampung Baru in KL, beside KLCC, the situation that you mentioned earlier, I believe that is Kampung Baru area. One piece of land, 4,000 square feet, 6,000 square feet, the beneficiaries who are entitled to it are up to 170 beneficiaries, 200 beneficiaries, because the inheritance, the estate process has not been expedited. Some of the beneficiaries pass away along the way. So their beneficiaries replacing their father's or their mother's portion, and that actually make the number of beneficiaries entitled for that small piece of land few hundreds people.
Yeah, exactly.
And when it comes to few hundreds, it's very difficult for
Yep.
you to get a compromise and to settle it.
That's true. And also the other part I would mention also is that for expats, those who are living in Malaysia and stuff like that, I have heard stories where when the land needed to be sold and had to be passed down, in common in Malaysia would be, oh, you have relatives in Indonesia, we have to go to them and we have to get either the consent or they have to claim some of the land as well, and that can happen from anywhere in the world, where you might have people in your wasiya. People in your faraid that are living anywhere in the world, and you have to go and get permission from them to do that. And that delays the process as well.
Yeah, for expat, I would recommend for you to do up an executor of appointments, appointment of executor document, appoint a professional party to execute it, so that this professional party are the one that entrusted to manage the estate administration process and to distribute it to your whomever that you wishes to, your beneficiaries. So that will make things easier for expats.
Well, I mean, I know this has been really, really educational. I appreciate your time. The one thing I think I'm getting out of this is it's better to leave your heirs with certainty, right, rather than uncertain. Right, uncertainty breeds fitna, it breeds arguments, it tears families apart. So the more you can do as a patron of the family to be able to do whatever it is you can, or matriarch sometimes, the mother is the one who has all the wealth, which is very possible, but leave it very, very clear so that everybody knows exactly what needs to happen. Really, Brother Ariffin, I really appreciate your time spending with us, and we'll definitely have you on another show.
Inshallah. Thank you very much.
Of course. Thank you for listening to Halal Money Matters. If you like what you hear, please do rate us on the app stores and also leave us a review. It helps other people find us a lot easier.
This material is for general information only and is not a research report or commentary on any investment products offered by Saturna Sendirian Berhad. This material should not be construed as an offer to sell or the solicitation of an offer to buy any security in any jurisdiction where such an offer or solicitation would be illegal. To the extent that it includes references to securities, those references do not constitute a recommendation to buy, sell, or hold such security, and the information may not be current. Accounts managed by Saturna Sendirian Berhad may or may not hold the securities discussed in this material. We do not provide tax, accounting, or legal advice to our clients, and all investors are advised to consult with their tax, accounting, or legal advisors regarding any potential investment. Investors should not assume that investments in the securities and/or sectors described were or will be profitable. This podcast is prepared based on information Saturna deems reliable. However, Saturna does not warrant the accuracy or completeness of the information. Investors should consult with a professional financial advisor prior to making an investment decision. The views and information discussed in this commentary are at a specific point in time, are subject to change, and may not reflect the views of the firm as a whole. All material presented in this podcast, unless specifically indicated otherwise, is under copyright to Saturna. No part of this publication may be altered in any way, copied, or distributed without the prior express written permission of Saturna.